Thank you so much for being here with us on this absolutely momentous and historical occasion. It is such a privilege to share this panel with one of my absolute heroes, Dr. William Schabas and Professor Ziegler, Dr. Ziegler. It is one of the most momentous things that I've ever done with my own life. The Wimlar, that is. And Wimlar has been such an amazing journey for me. I was part of the regional rounds. I'm part of this. And as part of this panel, I just will take 2 minutes to introduce the esteemed panelists and then ask the two questions that we've been hearing arguments about for a while, but it would be wonderful to hear answers to those questions from the horse's mouth. So without further ado, Professor Dr. Schabas is a professor of law at the Middlesex University, professor emeritus at Leiden University and the University of Galloway, and a distinguished visiting scholar at the Paris School of International Affairs, or Sciences Po. He is also the author of numerous international law books that include the international law on the International Criminal Court and the commentary on the Rome Statute, which was foundational for me personally. He was also the judge in the panel where 9 years ago I was part of a Moot Court competition, second edition. And without further ado then, Dr. Ziegler is the Associate Professor of International Refugee Law and the co-chair of the LGBTQIA Staff Network at the University of Reading. He is also a research associate of the Refugee Center here at Oxford. The two questions that the panelists are going to address us on are these, and I can repeat the second question later if the panelists so wish. What are erga omnes obligations, and how do these influence legal standing in a court of law? And what are permissible limits to treaty obligations?
I do recall once sitting on a moot, I think it was when I lived in Ireland, and I had asked this question of a student who had argued that something was erga omnes, and I said, don't you mean, no, yeah, that was it. He was talking about the Barcelona Traction case of the International Court of Justice, and which is where, the court enunciated this idea of erga omnes norms for the first time, I guess. And it was widely believed then that they said it because they didn't want to say jus cogens, which they waited until the 2006 to recognize, actually. But the student said, well, it's a jus cogens norm, according to Barcelona Traction. And I said, don't you mean erga omnes? And he said, well, isn't it the same thing? So I see him laughing, it's not exactly the same thing. They're sort of related, but they're not identical. And so we went in to deliberate, and I was there with some very distinguished barrister from Dublin, and I said, what did you think of that answer to my question about erga omnes? And the barrister said, that was a great answer, wasn't it? Seriously. So I just kept a straight face and didn't say anything. But there was often confusion about it. The erga omnes has become something incredible in just the last 5 years. So it's not just something that's there as a little intellectual problem to be solved. And although, as you know, the erga omnes basis for jurisdiction back in 2012 in the case between Belgium and Senegal was sort of just half erga omnes there, in my view, because really Belgium was claiming to be an injured state as well. And so although the court went out of its way to say, no, this is erga omnes, it wasn't pure. But it got pure, absolutely, in the Gambia versus Myanmar case. And it's now been invoked in at least two other cases, the South Africa versus Israel case and the Nicaragua versus Germany case. And since August or July of 2022, there have been something like 50 or 60 interventions in a number of cases. The Gambia-Myanmar case, Ukraine versus Russia, South Africa versus Israel. And although, as I say, that's not strictly speaking erga omnes, it is kind of the same thing. It's it's states that aren't injured saying, we want a piece of this. We have something to say. We want to be part of this litigation. There's one other thing that's happening a lot of in the last few years, and that's advisory opinions. And they're also kind of erga omnes. They require a vote by the General Assembly. Generally, there are other bodies that can do it as well, but usually it's the General Assembly. So you need a strong majority in the General Assembly. And then states come and participate in the climate change advisory opinion that was argued last December. There were something like 98 states or something who sent lawyers there. I mean, it's paradise for international lawyers. Just to think what an hour of an advisory opinion costs when you add up, say, 3 or 4 lawyers times 100, and they bill seriously at the International Court of Justice, let me tell you. I mean, it's mind-boggling to think of what those hours are costing their clients, shall we say. But to me, what's fascinating is what is a huge dramatic turn of states seeking the International Court of Justice to address what are fundamentally political questions in which they're not, strictly speaking, injured states, except to the extent that the whole world is injured by the state that's violating the norms. Or in the case of the advisory opinions, they're frustrated with the political fora, like the General Assembly, the Human Rights Council, the Security Council, and so they go to the ICJ. So it's never been, to me, the ICJ has never been as interesting and as exciting as it is now. I should also say that, as a general rule, all of these phenomena, the erga omnes applications, the interventions, and the advisory opinions relate very directly, or maybe a little less directly, to human rights issues. And so that's the other thing that's kind of interesting about what's going on the last 4 or 5 years at the International Court of Justice. You know, if you go back to the 1940s and you read the debates in the General Assembly and in the Commission on Human Rights, there were proposals then to create a global human rights court. And they never prospered. There were suggestions. Australia was well known for it, but it never got enough traction. And it's been revived periodically. About 15 years ago or so, I think Switzerland sort of started to see if there was some interest for this. There were some academics, Manfred Novak, Martin Scheinen, a few others who sort of picked it up and published on it, but nothing happened. And it's kind of a paradox, because we have these regional human rights courts, 3 great regional human rights courts. There's also an Arab Court of Human Rights that doesn't have enough ratifications yet to come into force, but maybe at some point we'll have that too. And they all thrive, they all prosper, and no one would say that they're stagnant or that they failed or anything. They're all successful. And yet there's no traction for a global human rights court. And is that because states are reluctant to create new international global tribunals? No, because they're turning to the International Court of Justice in these cases, and they've created the International Criminal Court. So to me, the clarity I get out of all this is that the International Court of Justice has become the Global Human Rights Court. That's what it is now. It's the global human rights courts that we wanted, not one that gets petitions, like the European Court of Human Rights or the Inter-American Court or the African Court, but a body that adjudicates the burning human rights issues of our time. And one that's rising to the occasion, I think. It wasn't always the case, and you can almost see the record of the International Court of Justice over time based on how responsive it was to these type of applications like the ones we're seeing now before the court. You know, do you all know the very first contentious case at the International Court of Justice? I'll give you a hint. Last year, I swam it. Come on. The Corfu Channel, okay, between Albania and Greece. And with 2 Dutch international law professors, we went and swam the channels, 3.5 kilometers in open water. So Corfu Channel is a great case. It was a case between the UK and Albania, and both sides lost. because in terms of the United Kingdom, the court said that the United Kingdom had violated Albania's sovereignty. Britannia rules the waves, but no longer. You can't go anywhere you want in the water and do anything you want. The whole world took note of it and said, well, that's a court we could trust. A friend of mine who did his PhD at Cambridge told me some months ago that he had gone on sometime in the 1970s. He was doing his PhD at Cambridge University, and he wanted to go and see, I know we're not supposed to call it by name here in Oxford, so the other place or something, you know. Yeah, there is some code here. You're not actually supposed to name it. But so he went over to The Hague because he wanted to see the International Court of Justice. And he thought you just go and knock on the door. In those days, there was no security or anything. Someone comes to the door, he says, well, I'm here. I want to see a hearing of the International Court of Justice. And the person who answered the door said, we haven't had a hearing for 4 years here. It was dead. You know, today there are 25 pending cases. The court, they're busy day in, day out. But it was like that. And then there was a great judgment in the middle of the 1980s against the United States for committing, for the use of force in Nicaragua under customary law. And the fortunes of the court started to pick up. But it seems to have taken a new turn in the last half dozen years. You know, we can speculate on what was the turning point. Well, my thesis is that the tipping point was probably, the turning point in this was when the advisory opinion on the Chagos Islands, which was issued in January of 2019. And, you know, again, like in the Corfu Channel, the United Kingdom was on the receiving end of that one. And as you may know, 2 weeks ago, I think, they reached agreement on the return of sovereignty to Mauritius for the Chagos Islands. And when he was questioned by some of the right-wing conservatives and the Reform Party people saying, you know, you gave away these islands, you didn't have to do it, Keir Starmer, the Prime Minister, said, we had to do it. We had the advisory opinion of the International Court of Justice. And he said, if we didn't do it now, it was likely we were going to have an application with a request for provisional measures in the coming weeks. So he said, we had to give it back to them. And we're waiting now. Both sides have to ratify the treaty, and then they'll give it back. And one of the things that will do for sure is that with Chagos being part of Mauritius territory, it means that the Chagos Islands, including this little military operation they have on the Chagos Islands, you may have heard about, falls under the jurisdiction of the International Criminal Court.
Yes.
So let's let Trump think about that one. There. So I'm a long way from erga omnes, but ultimately it's all about it. It was Hapiera who said, who referred to the actio popularis.
Yes.
Here. Is that Javiera, right? Is your name?
Yes. Yes.
Javiera. Yeah. You said, oh no, I mean, you were arguing fine for your client. You said, oh, this would be the actio popularis. And I thought to myself, what's wrong with the actio popularis? You know, what's wrong with it? It's great. And we need institutions that will, you know, address this. And, you know, I'm sorry for just one last idea I'll share with you. One of the great things I think about the ICJ that gets its credibility is that it is really a body that represents the world. It's true there's geographic distribution, and a little bit of it still harkens back to the old, you know, colonialist days and so on. But there's no guarantee now that the permanent members of the Security Council get a seat in the International Court of Justice. Only 3 of them are there now. And the judges come from all around, you know, from throughout the planet, and they can agree. But, you know, and they have a remarkable ability now to reach consensus on issues and to write common opinions in the advisory opinions. I mean, they write their individual opinions as well, but they generally reach a very good level of agreement, and that's also extremely helpful to the credibility and the authority of their judgment.
One explanation which is separate to other explanations in terms of content, and that is in terms of accessibility for perhaps the increasing interest is the ability for the the legal case to be effectively on the world stage on everyone's screens, right? So I kind of relate to a point that Eugene was making earlier about kind of lack of questions in a hearing in an international court, or maybe you made it, Bill, because that actually is one of the things that struck me. I remember as I was really glued to the screen with the South Africa-Israel case on both days. There was almost a sense of frustration that people were doing exactly what was described, right? Which is that they have read pre-prepared speeches that were timed, in even more Germanic ways than that I would have even applied myself, really almost to the second, dividing the time between them, but almost not allowing any time for judicial intervention and almost assuming there will not be a judicial intervention. So that what made it look to me a little bit closer to how a seating of the Security Council than a court hearing in a common law jurisdiction, and more of like global theatrics. Now that global theatrics has big benefits because it means, unlike other spaces internationally where some significantly mightier than others, here the Gambia or South Africa, etc., can bring a case and can capture the world's kind of viewing and imagination and can source a response and can lead many others, strong actors, to intervene. And I think to a large extent, some of these cases are almost worth it for the fact that they are brought in the way they are brought, almost irrespective of how they end up. And as we know, one of the challenges of the International Court of Justice is in some of these cases that, it has a mechanism that leads to that being the case, which is that provisional measures always have primacy, right, in terms of being heard and being decided. The consequence is that some of the merits cases take very, very long time, and we know even in something like Israel, South Africa, the likelihood is that I don't know. I was going to say that the war would be over before that. That's, nobody can predict that, but there will be a judgment only in a few years. And the interesting thing about refugee law is that the Refugee Convention has a provision that says in Article 38 that any dispute between the parties shall be referred to the International Court of Justice. So I find it quite instructive, actually, that there have been several cases in the Genocide Convention context, but no cases, for instance, in the Refugee Convention context. And I think that is a question we need to kind of almost ask ourselves, on what sort of human rights issues get traction and why countries bring the cases they do. I also interestingly want to say about the South Africa case, even though erga omnes partis was invoked as well, they did say in the brief, given that South Africa claim concerned its own obligations as a state party to the Genocide Convention to act to prevent genocide, to which Israel's acts and omissions give rise, South Africa plainly has standing in relation there too. So in other words, the Genocide Convention is quite unusual in the sense that even though there are erga omnes partis obligations, arguably, which I think there are, you don't need to go there, right? Basically, because if you think a genocide is happening or is about to be happening, that gives rise to your own obligations under the conventions. In a way, it's kind of superfluous almost to argue erga omnes, and you would argue it almost more politically than you would argue it legally. I think that's at least my impression. So those were just two, I think, general observations on erga omnes. On reservations, I think to me there are a few kind of interesting interpretive and again kind of normative questions again that come to mind. I think the first is this kind of label, the object and purpose, right, which is as elusive as it is attractive, right? So the easier ways, if you go to the Vienna Convention of the Law Treaties in Article 19, it tells you can have three ways in which reservations are impermissible. One is if the treaty tells you this reservation is prohibited, so that's easy, right? Or if it tells you you can reserve certain articles, but not others, like the Refugee Convention does. You can't have a reservation to non-reforma, for instance, but you can to other norms. But the more general one is this object and purpose of the treaty, which actually dates back to an ICJ advisory from 1951 on the Genocide Convention. But what does that mean, right? And I think actually the Moot was fascinating in this respect because it's I think it does. I mean, I was also insistent on kind of on that question of 12 bis because I think it highlights whether you could have a reservation to a treaty that to a large extent undermines its basis, but is not impermissible and still leaves other parts of the treaty intact. And I always have in mind something which is not technically a reservation, but operates in effect as a reservation, and again is in my field, but is something that would be known to people, and that is in relation to Turkey's approach to the Refugee Convention, right? So the original Refugee Convention from 1951 allowed states, which virtually all of them did, to say only refugees coming from Europe are going to fall within the scope of the convention, alongside having a dateline of 1951. Things have evolved, and in 1967 a protocol was adopted in New York to remove those two, right? To remove the two restrictions. And most countries that sign up to that treaty removed both of them, and a few island nations like Madagascar have decided not to sign the 67 protocol, which in effect means they have no longer taken on obligation. But Turkey did sign it, but then entered an instrument saying its instrument of accession stipulates the government of Turkey maintains the declaration that it made under the 51 Convention, which means that it only applies to people coming from Europe. That isn't technically, or wasn't technically, a reservation. And even if it was, as you've said in the moot, it's not clear where exactly you would challenge it under which non-existing court, because no one brings cases to the ICJ. But if we think about it normatively, right? So I want to branch out of the kind of legal, technical stuff, but kind of think normatively. I mean, what is the meaning then of signing the protocol when its very core function, given that 99% point something of people who come to Turkey as asylum seekers are coming from outside Europe? And the reality of today is that Turkey is a host to very many people who UNHCR classifies as refugees. It's potentially the biggest refugee hosting countries in the world, but it does so in a discretionary way under domestic law and without giving people refugee status. And so to me, it raises the wider question about what are international treaties for and what are signatories for. Why would you sign a treaty if actually the very core purpose of the treaty being to bind you not as a matter of policy, but as a matter of legal obligation that is executable or potentially something that can be acted on in your domestic courts is actually not something you necessarily want to give. And of course, I could give other examples as well, but I think it's quite. I often find it as quite instructive because of also the gap between the practice, which is to host refugees, versus the policy, which is not to recognize them formally.
Thank you very much. And as I call this panel to a close, I will just take 2 minutes to connect what the two esteemed panelists have said to the core of this moot court competition, from the history of how international law has progressed to the optimistic possibility that the ICJ has become the International Human Rights Court and potentially might even look into animal welfare and animal rights claims in the future, to a more realpolitik understanding of international law and treaties and how countries truly work with these treaties, and whether the International Court of Justice would ever become a forum that equally looks at all rights, including potentially animal rights in the future. It seems like a very interesting question to take back home. So you can take both of these opinions with you home and think about them, because you've had such rich content from both panelists. I'm so grateful to be a part of this panel and be here receiving all this information in all of these contexts. Thank you so much.
The topic for the panel discussion is comparative animal law, potential perspectives and advancements, chaired by me, but I think you all know me by now. We have on our esteemed panel Professor David Bilchitz, Judge Eugene Fahey, and Mr. Alan Bates. Thank you so much for joining us. I cannot actually believe I'm sitting on the same sort of table as these legends. So this is extremely exciting. Professor Bilchitz is a professor of fundamental rights and constitutional law at the Universities of Johannesburg and Reading. He is also the director of the South African Institute for Advanced Constitutional, Public, Human Rights and International Law, and vice president of the International Association of Constitutional Law. Honorable Fahey holds degrees in political science, law, and European history from the State University of New York. He is a retired associate judge of the New York Court of Appeals, appointed in 2015 after a distinguished judicial career spanning Buffalo City Court, the New York Supreme Court, and the Appellate Division. Mr. Bates is a barrister at Moncton Chambers since 2023, and since 2023 has been a deputy judge of the High Court of England and Wales, sitting in the Administrative Court and the Technology and Construction Court. He has acted both for and against all the main UK competition and sectoral regulators and the EU Commission. So our first question for the discussion, and what we will do is we will read out the question and then go one by one, starting with Judge Fahey and ending with Mr. Bates. So our first question is, what are the most significant contributions of your country to the development of non-human, especially animal rights?
Whenever you talk about American law, I think you have to obviously break it down into three categories in how law is made in America. There's, of course, legislative, judicial, and executive branch law. And I don't really want to talk about legislative law. Let me give you an example of why. There are no significant achievements in legislative law for animal rights. I think that's the fairest way to put it in the U.S. There is one case, though, that I want you to pay particular attention to, and it's really a judicial issue, but the state of California recently took a case up to the Supreme Court under Proposition 12, and there they sought to ban extreme confinement for chickens, calves, pigs, other animals that are used for factory farming. And the arguments went all the way to the United States Supreme Court. The name of the case is National Pork Producers versus Ross. It's 589 U.S. 356. I think it's going to be a very significant case. The Supreme Court ruled in favor of the state of California's ban that was put in legislatively and by referendum, I believe, in two parts. Now, this is I think a major case for a breakthrough in factory farming. And the legal analysis, however, was really a legal analysis that was done by Judge Gorsuch on the Commerce Clause. And he basically said, I may not agree with anything they do, but states have a right to make their own commerce rules. Now, the most significant legal writings that we've had outside of national pork producers is on the state level, is, I'm proud to say, I think, from my court. And my court is the New York State Court of Appeals, which is the highest court in the state of New York. It's the federal court. The Court of Appeals is the intermediate court. The Court of Appeals in New York is the highest court. It's called that. It predates the United States Constitution, the New York State Constitution. So it's pre-revolution, and that's where the title comes from. It's a little bit of difference. But there are two cases that came up. One is the case, three really, Hercules and Leo, two chimpanzees that went all the way up in a habeas corpus petition to try and examine legal personhood. The second is Tommy and Kiko, same arguments. And then the third was Happy the Elephant. They're happy that I recognize that. Again, poor Happy gets a lot of play. But those three cases, I was on the court for two of them. I wasn't on the court for the third. Now, so here's the sequence. The argument comes up for legal personhood. It's never been successful anywhere in the States. And the only place that I knew of where it was successful at all was in Ecuador. In the world at that time anyway. Hercules and Leo come up first. Now, to grant a case at the New York Court of Appeals, you need at least 2 votes of the 7 judges. I was 1 vote to grant case privately. This is confidential. At that time, it was confidential. I'm off now, so I can say this. And forget it, I'm going to say it anyway. So I was 1 vote for. All right, I don't feel constrained not to say it. For various reasons, other judges weren't in favor of it, and it lost. And there's almost never a writing that comes out after a denial of a leave grant. It wasn't that it was illegal procedurally, but it just never happened. It happened very rarely. I can only find one instance in the last 100 years. So Steve Weiss is a lawyer, that non-human rights project. I'm sure you're all familiar with that. I don't know how he knew, but he brought up Tommy and Kiko after that. I don't know how he heard. Somebody heard it, must have told him that there was one vote for it. So he thought he'd take another shot. He takes another shot with Tommy and Kiko, and it's denied for the first time the same way internally in the court, and there's no writing, but he reapplies. So when he reapplies, the vote is still the same, but I decided at that point, enough of this. I'm going to write something on it. And I found one case where a judge had written on a denial of a leave grant to express his concerns about the denial of the leave grant. And the only way you could do that is if you voted to deny. So I voted to deny, and then I went along with the vote to deny, and then procedurally, and then I wrote why I thought that this issue needs to be explored. So that's how the first writing on Tommy and Kiko came before the court. Taking this as a cue, the Non-Human Rights League had been pursuing the Happy case before, which is a strong argument, and it was a good case. They brought that case up, and that had more votes to grant leave on it. But I was at that point 69 and a half years old, and the case was put over until after I retired. So I wasn't able to argue on it or write on it afterwards. But the two other judges were, and they did a tremendous job. Judge Rowan Wilson wrote a dissent in that case, and Judge Jenny Rivera, and she also wrote a dissent in the case. Rowan's dissent covered the history well, and I believe tore apart the philosophical objections to considering the case. He recommended in his writing that not that habeas should be granted, but that it be sent back for a hearing. Judge Rivera did the same thing, but she focused on actually granting the habeas petition. She dissented on the basis of she felt it should be granted, which I believe is the only time, at least in U.S. jurisprudence, that it's ever been done. And I know of no other case except for the case from South America, because Estrelita, where it was granted and survived appeal all the way up. So their writings in and of themselves, in combination with Tommy and Kiko, I think really create the foundation for what we hope will be future arguments in other U.S. jurisdictions. So you have two significant developments. The first is the United States Supreme Court allowing California to make arguably the most radical move on factory farming that has ever been done in the states, and set a model for other states to do something similar, and the puncturing a little bit of the balloon by the New York State Court of Appeals on habeas corpus. Now, these things seem like significant decisions, and I think that California is, but the real significant decision is, it's one thing to set the intellectual agenda for the next court to come up on, say, an issue like personhood, but the most important thing is to win. And it's grand to be able to write and to say what you think, but I would have traded all that to be able to grant a hearing and to go forward. That's really what your aim should be. And as a judge sitting at that time, I would have altered the writing in whatever way I could if I could have gotten 4 votes on the court to grant habeas corpus. Those, I think, are our most significant U.S. developments, particularly within the judiciary at this point.
So I'm going to talk a little bit about South Africa, which has a great diversity in both its people and also has had strong relationships with animals over a very long period of time. It is one of the most defining and iconic elements when you think about South Africa. But for most of history, animals lacked any strong protections and have only had very minimal protections through rather weak welfare laws. And so with the new constitutional order that came into passing in South Africa in 1904, and there was a complex drafting process, there was some hope that there would be some protection for animals that came in. In fact, the second largest number of public participation petitions to the Constitutional Assembly advocated for animals to be granted some protections in the Constitution. Yet, unfortunately, that did not result. And so there's no express mention of rights for animals in the South African Constitution, except in the schedules that relate to the competences of national government. They can deal with certain aspects that relate to animals. That, of course, does not mean animals are excluded from all protections. And the question arises concerning the implications of existing provisions of the Constitution for animals. The Constitution itself in South Africa is fundamentally transformative, meant to shift the entire legal order. And so there's a real question about what the potential is of the Constitution to provide protections for animals. Now, importantly, I've made some arguments academically of why the Constitution can in fact be interpreted to grant rights for animals. In fact, it's not clear who the beneficiaries of rights are in the Constitution. And so I've made an argument of why it's possible to grant those actual rights which are in the Bill of Rights to animals themselves. Nevertheless, there's not yet a full, hopefully in time there will be, but there's not yet a full-scale acceptance of that idea at present. But I want to highlight an important moment that has occurred and one or two cases that have moved us in the direction, perhaps, of recognizing the foreshadowing of ideas around animal rights. So, of course, animals were classified in Roman Dutch law as things and not persons, as in many of the legal systems around the world. And this case came in 2016 before the Constitutional Court, and it related to a religious sacrifice of 2 camels in front of a crowd of people. It's quite difficult to kill camels, and the National Society for the Prevention of Cruelty to Animals came and witnessed. There were 8 attempts to slice the camel's throat, and the other one 3 times, and the inspectors came and shot the animals to put them out of their suffering. They then wanted to charge the people who were in fact involved with the slaughter with animal cruelty under the Animal Protection Law. And the National Prosecuting Authority declined to prosecute. And so the NSPCA, or the National Society of the Prevention of Cruelty to Animals, I'll use that acronym, sought to institute what's called a private prosecution. But in order to do that, you have to get a certificate from the National Prosecuting Authority to say that they're refusing to prosecute. And they said, we're not prepared to give it to you because this only applies to individual natural persons and not to a juristic entity, and so you don't have an entitlement to privately prosecute. And so they challenged this provision restricting their right to prosecute in terms of the Criminal Procedure Act, and in a significant finding, which is very important on a practical level, the Constitutional Court found that the NSPCA actually does have the right to conduct private prosecutions. But as part of the judgment, the court made a number of far-reaching statements which have shifted the position, I would argue, and the status of animals in South African law. After going through the history of animal protection, recognizing that the animal protection was done to protect the sensibilities of humans initially, the court made the following groundbreaking statement. Therefore, the rationale behind protecting animal welfare has shifted from merely safeguarding the moral status of humans to placing intrinsic value on animals as individuals. So what does that mean? It means animals have value and are protected in their own right. It's a kind of recognition that animals have a dignity. An important dignity is a foundation for rights in so many systems and opens the door for future development. And it also means that animals have interests that weigh in the balance when you're engaging, which was raised in the Moot, right, about the balancing of, which was when engaging with human interests. And so where there's a clash, you have to weigh them up, or you can engage in a proportionality analysis, as some of you mentioned in your memorials. But there was a textual problem for the court. Where are the animals in the Constitution? And the court found that animal welfare was connected with the constitutional right to have the environment protected in Section 24 of the Constitution. I'm happy to say that some of my academic work had some influence on the court, and they used what they called an integrative approach to link the suffering of animals to conservation, and showing respect and concern for individual animals, they said, is connected to broader environmental protection efforts. Animal welfare and conservation are intertwined. And those statements have fundamentally shifted South African environmental policy. The environmental agency said, we have no control over animal welfare. When we deal with issues, we're concerned with species, we're not concerned with individuals. And they've had to change their policy fundamentally as a result. And recently, I had the privilege to act as an acting judge on the highest court in South Africa. And I just wrote a judgment in an ordinary property law matter. So it shows you how something that can relate to just an ordinary matter, it had to do with property rights that someone had on someone else's property. I won't go into the whole thing, but the whole case started because two dogs of the owners could escape through the fence onto the other person's property. And in exercising their property rights, the person who had this right had no concern at all for the animals, and said, I want the fence to remain exactly as it is. And she claimed the right to do that. And the animals fell out, weren't that interesting to it. There were complex issues of pradial and personal servitudes, or different kinds of issues that some of you will remember from law school. And in my judgment, I actually tried to rediscover the aspect of animals, and that actually in Roman Dutch law, there's actually a principle that you have to exercise property rights in a reasonable way with due concern for the interests of the owner. And I argued that our constitutional order required actually concern for the interests of all those affected, including animals, because animals had intrinsic value. So in something like that, it's a dissenting judgment at the moment. Hopefully it sets the scene for some possible future developments. And I also recognize the interconnection between animals and humans, that actually that there is a close relationship between companion animals and humans. And the Constitutional Court in a previous judgment had recognized that human dignity protects the right to have significant, meaningful personal relationships in individual lives between humans. And I suggested that that can extend to the interrelationships between humans and animals as well. So these are creating the foundations, the possible ability for future courts to pick those up and hopefully develop them in some way. The last point, and I know I've got to conclude, that I want to mention is just to look at what are the concrete implications of recognizing intrinsic value. And it's interesting for this moot court competition because it's got to do with international law. And that related to the interaction between administrative law and the Convention on International Trade in Endangered Species. And so in South Africa, there's a rather horrible trade which goes on in lion bones, which are exported. Lions are killed, often hunted. And there is a quota in terms of this convention called CITES, which the minister is obliged to set. And the minister increased the quota and sort of doubled the quota within 2 years. And again, the NSPCA sought an administrative review and argued that in extending or doubling the quota, the minister had failed to consider animal welfare and what the impact would be on animal welfare. And therefore the decision was actually unconstitutional and invalid. And what the judge did in that case was said, well, given the ruling before that animals have intrinsic value and their welfare must be considered, it is therefore a relevant consideration that the minister has to take into account when exercising their authority, and therefore the failure to take into account the effect on animal welfare of doubling this quota in lion bones means that that decision was in fact invalid. And so that shows you how a recognition of the status of animals, or intrinsic value, can actually impact on what a minister or a government official must take into account when thinking about an ordinary decision, and can lead to a declaration of invalidity in relation also to something that links with international law.
Great. I think in order to answer the question, I have to define the terms of the question, actually, because the question was specifically about the contribution of our own jurisdictions to animal rights. Traditionally, the courts defend rights simply in terms of legal entitlement. So somebody, your next door neighbour's parking their car across your drive, so you've got an option as to whether or not you want to enforce your entitlement. And if you do, you can choose to come to court and it'll then be enforced, or you can just forget about it and waive your entitlement. So there hasn't been a sort of elevation of rights of particular value or rights that had a particular status. I think because we didn't have one single written constitutional document with a Bill of Rights or something like that. So all of our laws start off equal, if you like. There was also a concept in English law where somebody didn't assert a right, they should nevertheless have their interests protected by the courts. So, for example, children, people who didn't have mental capacity, the king or the queen, when we had a queen, had what they called it in Latin, or parens patriae jurisdiction. So the courts on behalf of the monarch had a protective responsibility for all the people in the realm. But that's not about exercising rights, that's protecting interests of people who can't protect their own interests. But if you look at it in terms of animal welfare, then obviously there's a lot to be said for England there, where some of the earliest animal welfare legislation, motivated by the sort of protective welfarist view of the world, it was something that was sort of an early adopter to the world. And I think it's really interesting when you look at the 1911 Protection of Animals Act, which prohibits causing unnecessary suffering to animals. I mean, there's that word unnecessary that appeared in the Moot, and there's obviously a big question about how you decide what's unnecessary and how much human interests, including economic interests, play into your assessment of unnecessary. And that's been a big part of our jurisprudence. But that same essential concept and that key criminal offence of causing unnecessary suffering that was in the 1911 Act is also in the Animal Welfare Act 2006. So in some ways, very little has changed. So we're an early adopter, but the basic framework has actually remained the same, and the welfarist focus has remained the same. Just to say one other small area of our contribution is that we were for quite a long time members of the European Union, which obviously we're not now. But during the time we were members, the European Union has, I think, made really very significant contributions towards protecting the interests of animals, partly because it's not only just looked at what's happened in its own realm, but has also sought to influence what other countries around the world have done. For example, with the ban on the marketing within the EU of cosmetics that have been tested on animals, even if the testing took place outside the EU. So I think that the UK's contribution, I say the UK now rather than England and Wales, it's the UK that was the EU member. We can claim some credit, I think, for those advancements that were made in the European Union during our membership.
The biggest challenge is straightforward. How do you change people's cultural awareness of the validity of this issue and not bring it out of the margins? The second thing is, once you do that, how do you make it economically feasible to make your cultural and your moral vision a reality? And those are not easy problems, but that's your challenge. I'm going to make 3 points. Second point I want to make is, on the plane, the most important lesson, on the plane over here, I've been reading a book. It's called Moral Ambition. It's written by a man named Rutger Bregman. And he talked about long-term moral struggles, abolition against slavery, equal rights for women, freedom to choose, the establishment of Roe v. Wade, and the abolishment of Roe v. Wade, and how that turned into a long-term struggle on the right. And the most important lesson he says here is that if you want to win your struggle, that you have to be morally ambitious. And that requires that when you leave Oxford, or when you leave Harvard, or when you leave Princeton, Yale, or you leave Cambridge, that everyone can't go out and become a corporate lawyer. And everyone can't go out and work for an accounting firm and make oodles of money and give themselves a comfortable life. You have to be able to both fight and want to sacrifice for your morals and your beliefs. And that moral ambition is what redefines the world. It happened I went the first time in England. My wife and I were in Westminster, and we saw a statue of Wilberforce in Westminster. And it rattled through in my own mind about his effect and how he changed everything. And the key thing there is, even for the abolitionists, you think absolutes aren't as important as victories. When abolition took place in Great Britain, didn't apply it to all our colonies. The United States continued on with slavery. Many of the other colonies continue on with slavery. It didn't apply to everyone who was a slave. It would only apply to certain men in certain age groups. In other words, fight for victories and sacrifice for your morals. That's his position, and I think that's one of the most, anyone who's here today, you're that kind of person. That's just the truth. But as you move forward, we want you to spread the news, spread the gospel, because that moral ambition will help redefine the world. So, where are you at right now? Well, legally, where we're at right now is animals are not humans, and they do not have, and they're not inanimate objects. And thirdly, they have no rights. In essence, they're property. They have no more rights in the building than the house that I have in the city of Buffalo. Where are we at in terms of science? In terms of science, here's news. Humans are animals the last time I checked, and all animals are not alike. And some subtleties need to be drawn and distinctions need to be made if you're going to achieve any victories. Morally, and this is what really prompted me more than anything in my first writing, what struck me, particularly when I looked at the video of Tommy in his cage in Gloversville, New York, was the pointless cruelty of this behavior. And personalizing it, as I went around to the other judges, makes a difference. That's why I talked to you before about personalizing it. The pointless cruelty of Happy sitting in a cage that's not much bigger than the 3 rooms on this floor for almost 50 years. This is for what? The entertainment of people as they eat their popcorn and walk by? There's no reason for this. There's no economic benefit. There's no moral benefit enhancement. There is no scientific benefit. It's simply for entertainment. That isn't sufficient to sustain the moral argument. Politically, and this is something that you have to think about, how do you win? I believe that you do this through arguing that sentience is a dividing line that you want to aim for. And I don't know where it is. It's going to take a while to figure that out, and sentience will change. It'll change not just biologically, but it will change because of the technology and the technological revolution we're going through that's going to affect what it means to be sentient. And those are the kind of issues that you're going to have to deal with. But it's possible. So I will leave it with that. It's not going to happen all at once. But if an animal, though, can be a legal person, then I will say to you that greater success is inevitable. So puncture that balloon, take the first step. It doesn't matter where in the world you do it. We will all be victorious in this particular struggle. Okay, that's all I have.
I'm not going to go through so many of the challenges because I kind of agree. I divided them into, and the challenges obviously differ with context. So South Africa, for instance, has got a history of colonialism and apartheid, and addressing the human suffering is so intense and so difficult, and that plays into, in some ways, overshadowing, in a way, the struggle around animals. But also, I think key is to recognize that animals have a history of terrible suffering, and actually there's a continuity between the two. So, for example, the colonial hunting parties used to go out and they used to go and shoot people as well as animals, right? And so there was a kind of continuity that existed in some way. And so to challenge that sort of binary opposition between the species. Economics, of course, there's a huge kind of engagement, and humans have so much, and we heard this in the Moot, right? There are billions of animals killed for food every day in South Africa. Trophy hunting, people come talking about unnecessary shooting of animals, right? Just to come to, get some thrill to be out in the wild and shoot something. Animals are trapped, they're exported from South Africa by sea, living terrible, terrible lives. And you know, there's sociologically an acceptance of high levels of violence in the society, sadly, and the use and exploitation of animals. There's the legal overhang, which I've talked to you about, of being classified as things, and the weak welfare protections. And then there's a lack of focus in the political sphere. And it's very hard to get above the parapet on issues around animals in the media. I mean, I noticed this as well. I mean, the UK has perhaps got more focus, but there's such a ridicule often, even in the liberal media here, around when there's some kind of question around animals that come up. And so overcoming that, it requires more organization, it requires greater education, and I think this initiative, and congratulations to Ankita on her dream of making something like this a reality, right, which is about engagement, yes. Which is spreading the discussion, spreading the engagement, engaging more with these kind of questions, and opening up to broader discussion and engagement. Now, one of the questions we were asked is, what are the most important lessons that we can learn from the development of animal rights in your country? And there's a lot to be said, so I'm going to try and limit it as well. The clash between human and animal rights often does not lead to progressive judgments, and we've seen this a lot in South Africa. And there needs to be clever litigation strategies that are developed. And I think one of the litigation strategies that we take, which was very, very successful in South Africa, and which was developed very deliberately, was around questions of LGBTQ equality. And in South Africa, the starting point, I mean, in pre-97, same-sex sexual relations were criminalized. And there was a recognition, even though South Africa was the first constitution in the world to say there would be no discrimination on grounds of sexual orientation, one could have gone as one's first case and tried to argue same-sex marriage. But it would have been an extremely unwise approach to do. And so there was a strategy adopted by the movement to start off with decriminalization, right? And then you start winning right by right. You earn a right to have your partner on a medical scheme. You earn a right, judges earn a right to place their partners on the judicial pension scheme. There were certain small rights, one by one, and gradually the court kind of built up a jurisprudence to bring your partner in from overseas if you met someone elsewhere, etc. Gradually a jurisprudence developed where there was a recognition that actually, well, same-sex relationships are as valuable as heterosexual relationships and deserve the same protections. And then eventually the marriage case was brought. And the court had no grounds not to find that marriage should be recognized, because ultimately everything else had been granted, and it was that kind of status of marriage that needed to be granted. And I think a similar thing has to happen, and it's a difficult question, but how do you, in a sense, build up from the smaller cases, right? Sometimes there's such shocking acts of cruelty that you really want to go for those shocking acts of cruelty, and we know also the billions of animals who are being farmed, etc., and living such terrible lives, and those would be the greatest impact cases, but they're perhaps not the right cases to take immediately, because they are the most challenging, and they're the hardest interest to affect. And so one needs to kind of go, and so what we're trying to do, for instance, in South Africa, I know it didn't fully succeed, but obviously there were some good judgments that came out in the US, is we currently have a case, for instance, challenging the keeping of 3 elephants in the Johannesburg Zoo. It's about specific animals. There's a lot of science around elephants and why they don't live well in zoos, and their complexity. And so hopefully that opens the door for certain arguments to be made that then moves, and we can then build more ambitious cases after that as well. I touched on that here as well, but very importantly, a lot of successful advocacy happens when you capture matters in scientific terms. So I was involved, there used to be this terrible practice in South Africa where there had been a determination that there were too many elephants in the Kruger National Park, which is a massive, massive area. And so what used to happen is they would go up in helicopters with guns and shoot whole families, right? You can imagine it's a type of a genocide of elephants, right? And it was called culling of elephants, but it was just mass killing, right? And essentially, one of the things that we tried to do is try to oppose that. And one of the key strategies that we used, and it was also supported by the science, was the science showed that culling had terribly harmful effects on populations. It increased birth rates, in fact, keeping animals reproducing at the highest possible birth rates. And also there were alternatives that could be used, which were developing in science, just like we know we could use contraception. There's something called immunocontraception, which can be used and can control animal populations in a way. And there were other things that were being done also to boost populations rather than keep the populations in a certain way. So we use the language of science to make those cases together with ethics. So I don't disagree that we need to be morally ambitious. So that was partly my role, but the ethics was often the more controversial element. But when you actually put the matter in the scientific terms, then you had some of the scientists come on board and saying, well, absolutely, we can't actually justify the continuation of culling. And so South Africa actually then provided enacted a regulation which actually effectively ban culling unless there's absolutely no other alternative, so as a matter of last resort. And so that practice for the last 15 years has stopped. I think we can also think about the possibilities and limits of the democratic process. And democratic processes are very good. There's a need for deliberation in parliament. It raises the profile in the media, forces the representatives to discuss the issues. On the other hand, it can often reinforce exploitative approaches. And since the dominant attitudes in society have not changed, it can also reinforce some of those negative attitudes as well. In terms of developments for the future, obviously one of the things, there's currently a constitutional review process happening in South Africa, and there's been a submission to actually include in those schedules that I mentioned to you a recognition that all levels of government have duties around animals, so to kind of not allow governments to kind of pass the buck because they say it's not my competence. And then hopefully in turn there could be a more ambitious look at constitutional amendment to actually include at least protection for the interests of animals. And statutorily, there's at the moment a change to animal protection law, and it interestingly relates to what you were saying about EU law, because, and it's sad, it's actually for an exploitative reason. South Africa wants to export meat into the EU market, but the EU has stronger regulations than South Africa. So in order to make its regulation compliant with the EU, it needs to undergo a process of law reform to improve its animal protection framework. So it shows you the way in which there could be a slightly upward pressure, not a rights-based upwards pressure, but nevertheless an upward pressure that international law of a regional kind places in relation to animal welfare. And so that, as a result, that's enacted and it's begun a process of changing the welfare law. And just to mention some of the things that are being proposed, we just had a big colloquium a month ago discussing these issues, we'll see what happens, but at the moment there's proposals to recognize animals as sentient beings with intrinsic value, which, as I say, is not such a big step given the Constitutional Court's recognition that humans have a duty of care towards animals that includes not harming them and enabling their flourishing, a presumption against causing harm to animals, and then requiring any harm to animals to be justified according to a principle of proportionality, specific standards developed in particular areas through specific regulation in areas such as testing, food industry, and entertainment, prohibiting extremely cruel acts such as circuses, sow stalls, and battery cages, moving animal welfare to the Department of Justice from the Department of Agriculture, which is imbued in the exploitation of animals, and creating a special animal protection office dedicated to policy around animals, enhanced powers of prosecution for multiple organizations, and enhanced transparency and reporting requirements in animal use or abuse industries. So in conclusion, I'd like to end with the words of what the Constitutional Court said in its groundbreaking judgment. It says that animals have shifted from being mere brutes or beasts to fellow beasts, fellow mortals, or fellow creatures, and finally to companions, friends, brothers, and sisters. And so let us hope that we can together make that change into a world where we find that we respect each other, not because of the nature of the species we belong to, but according to the nature of who we are as beings and the lives that we wish to live and flourish in. Thank you.
Looking forward, I mean, if we gather here again in 15 years and we haven't had an absolutely horrific global conflict, I'll be relieved. But at the moment, looking at the world as it is, we are in an incredibly dangerous world. And within that context where defense spending is rising, where there are all those threats, trying to get people to focus on the protection of animals and advancing this agenda, I think is going to be significantly more challenging than perhaps we're used to. And the problems are particularly acute for the United Kingdom, if asked to give a comparative perspective, because of the economic situation that the UK and indeed the whole of Europe is. I think we're finally waking up in Europe to the fact that we're actually quite poor compared to how we were 20 or 30 years ago. We haven't invested the way we should have done. We haven't innovated the way we should have done. And people have been quite comfortable, but I think they realized that this was all a mirage. And so within that context, the UK, for example, is now trying to focus on economic growth, negotiate trade deals with China, with the US, etc. And animals, to be honest, that's one of the things that animal interests are going to give to some extent in that, whether that's more fishing by European countries in our waters, whether that's relaxing some animal welfare standards that we expect for meat coming in from the US, for example. Those are all the trade-offs that are being made. So I think there's no getting away from the fact that it's going to be a more difficult environment we're operating in. As for lessons learned or how I think we can go forward, I mean, the lesson I take away is that we need people like the students in this room who don't just care about animal rights, animal welfare, but learn the law and are prepared to do the difficult and the complex stuff. Because in the last few years in the UK, there have been big campaigns with groups campaigning for things which, to my mind, just within these four walls, haven't been of great value. So, for example, the campaign to have legislation saying that animals are sentient beings. Okay, it's easy to get a lot of support for new legislation that perhaps won't be enforced in any way, might not have any consequences, but it enables you as an animal protection group to galvanize your supporters, raise funds. That's all very important to an extent. But we're in the business of actually changing the amount of animal suffering that there is in this world, right? So we have to keep asking ourselves, what's the contribution that we're making by what we're doing to actually reducing the amount of animal suffering, bearing in mind that there are billions and billions of animals in intensive animal agriculture, and on a global basis, that is increasing all the time. And it seems to me that if we're going to have any chance to have any impact on things like trade deals that are happening, we really need people to influence what a highly complex process, the process of agreeing a trade deal. There's loads of interest groups, very well resourced lobbyists from industry. A lot of it's happening behind closed doors. And just being outside with, getting signatures on a petition or whatever, unless you're prepared to engage on the real technical detail, you're not going to achieve valuable outcomes. So that's my plea to all of you. Don't go for the easy stuff. Go for the hard stuff. We've really got to put the work in and get on top of the detail. And I think having people in this movement who've got legal expertise, as well as, of course, other expertise that needs to come in, scientific expertise, etc., that's what gives me hope that we're able to respond to what is going to be an extremely challenging next couple of decades.